Hi, and welcome to CAM Resource Podcast, Episode 2, Service and Emotional Support Animals. Hello, today we are here at Rabin Parker P.A. We're fortunate enough to be here, thank goodness that they volunteered to talk to us today. I'm going to let you each introduce yourself because I'm sure you'll do it better than I am. Monique, you can go ahead and start.
I'm not so sure about that, but my name is Monique Parker. I am one of the founding partners of Rabin Parker P.A. Firm has been in existence for several years, and we specialize on community association law. And in fact, that is all we do. We only represent community associations within the state of Florida.
And Adam, go ahead and introduce yourself.
My name is Adam Gurley. I'm an associate attorney here at Rabin Parker. I have worked in association law for about 3 years now. With the firm, I handle most of the litigation matters, a lot of fair housing matters and things of that nature, enforcement matters and things along those lines.
And that's perfect because today we're talking about a fair housing issue. Service support animals, and most community association has felt the wrath from this. I hate to say it like that, but really,
Yeah.
We've all probably experienced someone trying to bring in a support animal that we probably know isn't really a service animal, let's say. So if you guys would kind of help us explain what is really a service support animal, and then we'll talk about what we can do as managers and board members to deal with this issue.
Sure. I'll start and I'll address a big issue, and it's kind of one of the fundamental issues that people need to understand when dealing with the Fair Housing Act and these types of animals. And the first is the difference between a service animal and an emotional support animal. A service animal is an animal that is specifically trained to perform a task, and that task can be pretty much anything, but it typically would relate to seeing eye dogs, which assist the blind, hearing dogs, of course, who are trained to hear noises and alert their owners to that. There are seizure dogs that can alert their owners to a potential seizure that the owner may have. I believe there are even dogs that have been trained for diabetics, and they can detect when glucose levels are changing. So there are animals that have very specific set of trained task functions that they perform for their owners, and those are service animals. Emotional support animals don't have to have any kind of training to be protected still by the Act. They are just fuzzy and cute and lovable and all those things that we like to have pets for, but the difference is their owners have an identifiable disability that would allow them to keep that animal for the purpose of providing emotional support. And that disability could be anxiety, depression, or any one of a number of factors that would impact their daily life. And so those animals, it doesn't matter if they've never been trained or if they've never even set foot into any type of dog or cat schooling. It's simply the fact that that animal is lovable and comfortable, and it really helps the owner feel better for some identifiable reason. So a lot of people get hung up on the fact that an owner might bring in an animal that's not trained to do anything, and they say, well, it's not a service animal, so we don't have to allow that in. But that's actually not the case. The Fair Housing Act actually allows people to have both trained and untrained animals depending on the disability and the task that is being performed, whether it's trained to perform it or it's just having fun. So that's a fundamental issue that needs to be understood, and it is frustrating, as you said, because especially with emotional support animals, they're even harder to identify. And then another issue that I briefly mention is this idea of registering service animals and registering support pets. The fact that they're registered is not the end result, and I think we'll talk about that a little later in the podcast, but I do want to put that out there right in the beginning, that it's really whether or not they're performing a task or giving some sort of aid or service to the disabled person that is the question at issue.
Okay. I know it's harder in communities where they don't allow pets, but I do see the side that I've seen some, people that really build their whole lives around their pets. So I do understand the other side of it. I think it's just hard because in some incidents, we know it's really just, they're just taking advantage of it. But maybe not. We really don't know what's behind the door, so.
Yeah, and that's what we see a lot with service animals. That's a lot more difficult to prove
Right.
when an owner comes in. It has to be, as Monique said, specifically trained to serve a purpose that assists with the disability. So a lot of times we'll see a resident come in and say, I have a service animal and I'm entitled to an accommodation under the Americans with Disability Act for this service animal. And most of the time the boards will say, it's not a service animal, it's not trained for a specific task, we can deny it. And the reality is that even though they assert it as a service animal, you still need to go back and say, well, they said service animal, they probably meant emotional support animal, and now we need to go down that track and say, okay, is it an emotional support animal? Two other limitations on service animals that I think are important because it kicks out a lot of those service animal claims is that the service animals are actually limited to dogs or miniature horses. Those are the only two animals that can be service animals. Anything else, it has to be an emotional support animal under the Fair Housing Act, can't be a service animal under the Americans with Disabilities Act.
So that's service animal.
That's service animal, have a miniature horse or a dog. The other thing with service animals that we see a lot is boards will look and say, well, can they provide some sort of certificate or some sort of verification that the animal's been trained for this specific task that helps with the disability? And the answer is generally no, because it doesn't require professional training. It just has to be trained by someone to serve this purpose. So even if the owner asserts that they personally train the dog and that the dog now achieves this goal and helps with the disability with the task they've been trained to perform, that is generally sufficient if the documentation supports that.
I even had on one of my associations a lady who actually trained the dogs. So she had several dogs, and it was nice to see. You always want to run and pet them, and they say, don't pet them.
Sure, yeah.
Actually, Diana, that brings up a really good question because that has also come to us from a client asking, well, there's an owner that lives in our community, more a no pet community, or they have restrictions on pets, and an individual owner is a trainer and they want to be able to train the service animals on property, and if they are in fact service animals, does the accommodation have to be granted? And in that case, no. The fact that the animal is a service animal, again, is not exactly the inquiry. The inquiry actually begins with the owner. So a perfectly capable owner that is merely training service animals for others is not entitled to the same benefits and protections under the Americans with Disability Act and the Fair Housing Act. And let me touch on that. One other thing, there's a lot of confusion between the ADA and the FHA. Most of the time, when we're talking about community associations, and I believe that's probably the predominant listening group we have here, the Americans with Disabilities Act doesn't apply, or it applies very, very remotely. What the law that we really are focusing on here is the Fair Housing Act, and the Fair Housing Act requires housing providers, which does include an association, as well as landlords and other types of housing providers, to give accommodations to owners with disabilities. And those accommodations can be pet accommodations, what we're talking about today, or other types of accommodations. But the Fair Housing Act is actually the law that we want our associations to focus on, and not the ADA.
So if I'm working as the manager and someone comes in or is actually, looking at our facility to purchase or rent, and they bring up the point that they have an emotional support, I think that's where we get a little more gray area.
Yes.
I think the service animals are usually a little more clear anyway.
Sure.
And
Most
they're-
people don't have any objections to what we
Right.
really
If we can
deem
see-
service
yeah.
animals.
So it's the emotional support, and sometimes it's not even that we have a problem with. I think it's the, if there's multiple animals. So what steps should we take as managers to prep us for that happening? And how do we deal with it if, as someone comes in to actually, if we're just talking about them purchasing, that's kind of a good opportunity to figure out what's happening.
Sure, and one of the best methods to deal with these claims is to get with your boards of directors and say, look, we need to establish policies for the community on how we're going to deal with these things, more specifically, what we're going to require and how we're going to analyze those things. And to adopt those provisions in writing serves two purposes. One, it helps the board and subsequent boards know exactly the process that they need to go through. The second reason it helps is if an issue arises down the road where there's an allegation of discrimination from an owner, who says, I submitted this claim, I submitted everything I was supposed to, and they're discriminating against me, the first thing some of the local housing authorities will ask if a discrimination complaint comes to them, and we'll get to that in a bit about where these discrimination claims go, the first question they ask is, well, does the association have any written policies and procedures in place that show that they follow from A to Z this exact process for every single applicant? And if you can show that, oftentimes that helps show, look, we didn't discriminate, we followed the same pattern A to Z that we follow for everybody. So that's really the first step, and I think one of the more important steps is to make sure there's something in writing adopted by the board at a board meeting that says this is how we handle these procedures.
And it'd probably be a good idea to contact our attorney, or you guys,
yes.
to have that written up, correct?
Yeah,
because
yes.
we could just say, well, we're going to look at it and let you know.
Right.
So maybe have some guidelines written
Absolutely.
up.
Go meet with legal counsel when you adopt those guidelines. We've adopted or drafted those guidelines for boards to review, make any necessary revisions, and then to adopt. So to have legal counsel active in that role is very important. And once you get the response from the resident who's seeking to move in or already lives there, once you get their documentation and their response, it really is something that is examined on a case-by-case basis. There's no broad brush approach to this where you say we turn down all of X and we allow all of Y. It really has to be a case-by-case analysis based on the specific facts of each request. So it really is something that should go through legal counsel, frankly,
especially
every time.
if you're denying.
I would say every time, but especially if you're inclined
if you're
to
denying, definitely set
Definitely if you're denying, and if you're accepting, and you accept based on insufficient information, you get yourself in trouble down the line, because now people will say, well, you can't turn me down when I submit insufficient information because you accepted it from the person before me.
Right.
So it's really walking this tightrope of making sure you get exactly what you're supposed to get, so you're not denying unnecessarily, and you're not subjecting yourself to problems down the road and enforcing your pet restrictions by accepting too little and allowing the dog to remain there. So that's really the biggest benefit to getting legal counsel involved. I think the other thing is, I mentioned the local housing authorities, and like I said, we'll talk about those avenues for complaints in a bit, but as a sneak preview, there's no charge to file these discrimination claims. You don't have to hire an attorney. You go right down to these offices. They'll help you fill it out.
Or online.
Or online even now. Yep. So the number of discrimination claims we've seen against associations recently has really skyrocketed. And so the exposure to individual members of the boards, to association managers, has really increased the potential liability there. So to take these things and get them in the hands of your legal counsel will only serve to protect those agents of the association.
I want to add to what Adam said. He's absolutely right, and a lot of the time we get questions from our clients that are relating to the policies that they should develop, and some people want to even amend their governing documents to include provisions relating to service animals. So let's take one small step back and talk about the policy that Adam was referencing. That policy needs to be very, very general in terms. It needs to be something along the lines of, okay, if we are presented with a request for an accommodation, we're going to ask for documentation supporting the existence of a disability, a description of the requested accommodation, and the relationship, like why they need that accommodation. And it really can't go beyond that. It's got to be very, very general in nature. And then once the documentation or the information is supplied, it's that information that should go to legal counsel to analyze and digest and to find out if it actually meets the requirements of the Fair Housing Act. The reason for that is there are so many pitfalls. As Adam said, liability is easy to establish, and the law changes, not necessarily the actual statutory codified law of the Fair Housing Act. That's relatively stable. But the cases that are decided regularly that interpret that act are continually changing what we believe the act to mean or to stand for. And the parameters for what you can ask for are getting tightened down almost every couple of months. We get a new case that says, well, now you can't ask for this. It's a violation if you ask for X, Y, or Z. A good example is we used to ask for a description of the exact disability. We want to know if you're asking for an accommodation, seems fair enough that we should be able to ask, well, what is your disability? Well, now there are cases saying that you cannot ask about the specific disability. You can ask about maybe the nature of the disability, but you can ask for the specific disability. And if the disability should be open and obvious, then you can't ask at all. You need to just assume that the disability is there. For example, if somebody's walking with an assisted device, a walker or a cane, you can't ask for evidence of that disability from their doctor or their medical provider, because you can visibly see the disability. So there are so many things that an association could accidentally ask for that they're not permitted to ask for, and that can give rise to liability. The other reason why I don't want to see it in the governing documents is because, as you alluded to in the beginning of this podcast, without actually saying it, let's call a spade, people are using it, you know, to get what they want when it's not really a legitimate need. And so what happens is, if you put that information in your governing documents and it's recorded and it's out there, you're basically telling people how to beat your own documents. If you don't want to comply with this restriction, then go ahead and give us this, and you're going to get away with something. So we want people that are going to try to circumvent the rules to, you know, have to at least do their own due diligence, because those who legitimately need the accommodation, they know what they need to provide, and it's not going to be a problem. It's those that are trying to sidestep or to get away with something that don't really know what they're supposed to do, and we don't want to spoon feed them with the answers.
So is there, you know, talking to many boards, I've heard them say, well, we need to charge a fee for this because we're having to pay legal counsel for that.
Not a chance. That is a terrible idea. Now, back to the Fair Housing Act, I will say that certain accommodations, and it rarely relates to pets, but theoretically something could come up that would relate to pets. But certain accommodations, depending on what it is, you can shift the cost of the actual accommodation to the owner. A good example is a chairlift for a pool. If they need to install a chairlift for the pool, you need to allow them to do that, but the cost of that can be borne by the owner. I can't off the top of my head think of something relating to pets, but you know, there could be, and the owner could be asked to bear whatever that particular cost is, but not just generally legal counsel. That's the cost of doing business, and you know, all associations should have a legal budget for that type of advice.
So the comment that I hear most often about service emotional support animals is that you can just go online and get a certificate. So is that true, or what?
It is absolutely true. You can just go online and get a certificate, and I think my favorite online website is the Dogtor, DOGTOR.com. I promise you it's there. If you look up the Dogtor.com, you can get yourself a certificate for, I think the cheapest, the most common is $99.99 or whatever the case may be. So there are a lot of websites out there for both service animals and for support pets. But here's the irony of it all. It means nothing.
Okay.
Those certificates that they get, even for a service animal, really don't mean anything. You do not have to accept those certificates as the end all be all of whether or not an accommodation should be granted. In fact, the ADA does not even recognize any type of formal registration for service animals. So that's just something that people are using to make money.
And so that's why it comes back to what Adam said, get your guidelines.
Yes.
So
exactly.
that you know not to just accept that.
Right.
Yeah.
And oftentimes when we see a standard certificate or some of these ID cards that come directly from an online site, you should conduct your due diligence and look at the totality of what you've been provided in making your analysis. But oftentimes in our office, if we get one of those cards, that's almost a red flag to say, okay, we need to look into this a little further, because you know, typically those websites, they don't require any doctor visit, they don't require any support. So that's almost a red flag more often than not, that okay, we're probably not about to get, you know, what is needed to be provided to approve this.
Right, and there's the registration sites where they can register their pets as a service or an emotional support animal, and then there's also the sites where they can get their prescription. You know, they go online, fill out a few you know, questions, and then they get a doctor's prescription from an actual doctor back. The interesting thing about that is we've been able to successfully challenge them because they're all the same. We actually, I think, got the exact same one for 2 different people on the same day, or like one day after the other. It's same doctor, same exact prescription, same wording on the letter, everything. I mean, identical, side by side, but for the name of the patient. So we're able to challenge those as well, even if they have the magic language, just because we know it's nothing more than a form or a template.
Okay.
If it was given by an actual, doctor for an individual patient, it might have what they need to support it, but we just happen to know that those are
Right.
not accurate because of where they come from.
So one of the things that managers have a problem with is, okay, the person's come in, it's all legal, they have their support animal, and it's the other people that come in. Well, if they get to have an animal, what's the best way to handle that? In just a short little saying, well, go ahead and say it, Adam, so that
Sure. Just the special circumstances, that they submitted the documentation and are entitled to an accommodation under the Act. I don't think it's recommended to say much more than that.
That's
You
what-
get into
yeah.
the risk of disclosing some of the disabilities and
Right.
handicaps that substantiated the accommodation request to begin with, but enough to let the owner know that, hey, this is an exception based on the Fair Housing Act or the ADA, whatever the case may be, without disclosing any medical information or anything beyond that.
So, speaking of that, in associations, a lot of time we have to disclose certain things to owners. How about that personal information of, if it is an emotional support, can we keep that as records that are not disclosed to another homeowner?
Our opinion is that is confidential information that does not need to be disclosed. It is not an official record of the association. And sometimes we'll even help, our office will be a buffer between the requesting parties and the association, and we will agree to hold that information,
Oh,
reveal
very
it
good.
to our clients,
That would help.
but then either keep it in our files, our legal files, or otherwise dispose of it once the opinions and everything are generated for the protection of the owner. So those that have legitimate disabilities and need for them, there are protections, and it's not, they don't have to have all of their public or their private information displayed out to the public. But they do need to disclose enough for the association to be able to make an informed decision to protect the integrity of the governing documents.
So let's say someone's come in with an emotional support animal, which is different, as you described, as a service animal. I think where we're a little iffy is someone comes in and questions it. Do we have to be clear on how we say, well, that is an emotional support animal or that's a service animal? Because how we say that, how they all the PIAs, pain in the associations, run back and, say, well, I looked up emotional support animal and that's not, so we really have to be clear on, can we say that's an emotional support animal? Or how do we respond?
I would try to respond in a manner that is more akin to that person is permitted to have an animal as an accommodation under the Fair Housing Act.
Perfect.
Because
Perfect.
if you say
that's
service animal or emotional support animal, now you're hinting towards what the
Yes.
disability might be.
And that's what I was getting
Exactly.
at.
So I think it's much easier and better for the association to just say that person has established an entitlement to an accommodation under the Fair Housing Act and leave it at that.
And we'll put that wording on the website.
Sure.
Because we'll forget it after a little while.
Yes.
And that's where the involvement of legal counsel helps, because that's your ace in the hole as the property manager to defer all of those questions
Yes.
and say, well, it's been provided to legal counsel and they handled it.
Right.
Yeah, that's
And
perfect.
so that's sort of the way to defer those questions from the owner, I think.
I love a buffer.
That's
Yeah.
right. That's right.
That's right.
That's right. Shift the blame to the attorneys. It's always the default.
So I think we've all an opinion that the first thing we need to do is set some guidelines. All of the associations need to do that. And I would say, do you think even if you already allow pets, should you set those guidelines anyway too? Because is there a difference between, I noticed that you said in the beginning that service animals are only certain, I think it was a dog and a pony, was it?
Miniature horse.
Miniature horse. Oh, that's interesting. Can't wait to see that. And then, so in emotional support animals, what kind of animals would comply with that?
Go ahead, Adam.
Almost anything under the sun. I say almost
Really?
because it's still an area that's up for debate. It's a case-by-case analysis, like I said in the beginning, but we've seen everything from snakes, tarantulas, birds, cats, dogs, your more standard.
Squirrel.
More recently, we received a request for a squirrel as an accommodation, and not just any squirrel, an eastern grayback squirrel. I didn't know that we got right down to the breed of squirrel, but apparently that is the case. So we have a request for this squirrel that is being alleged to be an emotional support animal. The squirrel was actually discovered by the board because the owner of the squirrel was carrying it in a carrier across association property. When the squirrel, I don't know if he's able to pick locks or what he did, but he found a way to get out of his carrier, and as squirrels do, he climbed a tree. So this gentleman climbed the tree to try and retrieve his squirrel. Now, how he figured out what was his squirrel versus the other squirrels in the tree, I'll never know. I don't know if his squirrel wears a diaper, and that's how he was able
It
to
was that
distinguish.
certain species, don't
Yeah,
they
yeah,
know?
it was the eastern, gray squirrel.
They look different.
Yeah, so he got the squirrel, but everyone wondered why this guy's in a tree chasing squirrels. So that sort of brought attention to the fact that the animal was there. We learned that these squirrels are fed with little baby medicine droppers and things like that. So right now, that's the issue for the association and the board of directors to look at the documentation that's been provided and say, okay, is this a reasonable accommodation request that needs to be granted? And so that'll show you really the scope of animals that we're talking about here, where the service animals are really limited to the miniature horse or the dog that really is trained to serve a purpose, versus these animals that, it runs the gamut. It runs the gamut. And the key phrase for these accommodation requests under the Fair Housing Act is the request reasonable?
Reasonable.
So that's the big question, which of course is a subjective test. There's no test to establish
And
reasonableness.
whose perspective is it? The
Right.
judge's
Exactly
or-
right. The judges
Yeah.
eventually. It's the boards at that time and looking at the totality of the circumstances. So, if you have somebody that has 2 dogs and they say one's a pet and one's an emotional support animal, well, emotional support animals don't qualify as pets. So if you are a 1-pet community, technically they're in compliance.
Right.
So that's reasonable and you're fine. Now, we've had a community where an owner had 4 dogs. They were 4 large dogs. You could certainly take the position that in a condominium unit, 4 large dogs is not reasonable. That's way too many. But again, we're balancing on this what is reasonable question. And if push comes to shove and it goes all the way to the end, ultimately it's a judge that makes that decision as to what's reasonable.
So let's talk about that a little bit. Let's say we think it's unreasonable and we challenge it. Is it just first, does it ever go to HUD, or how does that work? What's the process if it goes?
It can go a few different routes. It can go directly to federal court as a the Federal Fair Housing Act claim. The state of Florida has the state's equivalent to the Federal Fair Housing Act, so it can be brought as a state claim. Typically it goes through federal court rather than state court. But as I mentioned earlier in the podcast, there's the local authority, the local Fair Housing Authority. We have the Pinellas County here locally, Fair Housing Office. We have the Tampa Fair Housing Office. And the role that they play in all of this is that they're free of charge. The owner can come in, or the prospective resident comes in and says, I think I've been discriminated against. They'll be given an application. Those offices will typically walk the owner through the application and say, here's what it needs to say, or here's what it should say to establish discrimination and to substantiate your allegations. They'll take that application and they'll conduct their own internal investigation. They'll get statements from the association, statements from the board, the manager, and they'll conduct an investigation. And if they find that there has been discrimination based on their investigation, then they could potentially assign a county attorney or a city attorney to represent the owner at no charge in state or federal court. So it's really the Fair Housing Office complaints are a precursor to litigation in a court of law, but if they go that route first, it's very easy to do, it's at no cost to them, and at the end of it all, they could end up with free legal counsel if they go to court, which is a big issue for the association because they don't really have any skin in the game at that point. They're not ponying up attorney's fees or anything like that. They can proceed with their case, and meanwhile the association is funding heavy litigation to defend this thing.
So what is HUD? Where do I hear the words HUD coming from, and what exactly? Do they play a role in this, or?
HUD is actually the Federal Division of Housing and Urban Development.
That's what I
So
thought.
that's under the federal law, and that is where all of these acts that we're talking about are promulgated, and that's the administrative agency that will issue opinions regarding the application of those particular acts. Sometimes you might hear your attorney say, well, HUD just issued an opinion.
Yeah.
Well, that means that a question came up about one of these federal laws, whether it's ADA, FHA, and there are others as well, and there was ambiguity about it, so HUD comes out and says, well, this is how we are interpreting it, and this is how everybody needs to abide by the law. There is also an administrative enforcement agency within HUD as well, but what typically happens is if an owner goes online and files a complaint with HUD, which they can also do, HUD will review it and they'll defer it to local administrative agencies if there is one. And because there are local administrative agencies in our area, they're all deferred out from HUD to us. We've not yet seen one proceed through HUD. They all come out to our local administrative agencies.
Some of the involvement that HUD has in the local area, and this is more the local human rights offices as well, but it all goes through HUD, and a lot of the funding's through HUD, and the requirements that are passed down to them are all from HUD. But they'll conduct in associations and apartment communities, sort of submitting these fake testing applications that they'll send to property managers, to boards. They'll have individuals pretend to be prospective tenants, be prospective owners, and they'll submit these and test your policies and procedures. And so that's part of the role they play as well, is just this fact-finding mission, or this sort of undercover mystery shopper type of deal, where they'll come and test your policies and procedures. So even if it's not an issue you have presently with some of the tenants that are actually in the unit, it's important to know that these mystery shoppers, I'll call them, are out and about and conducting these tests, if you will.
So a couple things from a summary of this podcast today. I think we ought to also talk to all of the employees that deal with people, make sure that they're saying the correct things. We get our guidelines together. We've got to get our stuff together, because if we, I mean, this is serious, because it really could result in a lot of litigation, and that's our biggest job as managers and board members, and is to avoid litigation. Not that we don't love you guys.
No,
Sure,
actually,
sure,
but we'd much rather be involved in the beginning,
Yes.
helping our clients avoid litigation, than at the end and having to drag you guys through litigation, which is much more costly and frustrating, and it's not a pleasant situation for anybody.
Now I have another question, because podcasts could be heard anywhere. This is the state of Florida. Is this a United States, America thing, or is it just a state of Florida thing? So any state that's listening to this would do best to do these procedures.
Right, and we're fortunate in Florida that our state law actually mirrors the federal law. So we actually have the umbrella over us, we have the Federal Fair Housing Act, and then we have, of course, the Americans with Disabilities Act, which is also federal. So that's all of the United States of America. Then our state law here in Florida mirrors the Federal Fair Housing Act, so we don't have to try to learn two different things.
Right.
The Housing Act is actually going to take priority over the state law, but the state law can actually be more restrictive. So every state, they need to be aware that even though we're talking generally about the Federal Fair Housing Act and Florida law, their own states may have additional requirements or additional burdens that they should look into with their council to make sure that they're not missing something else, because it can be, the states can be more restrictive, and by restrictive I mean more protections for the disabled, and when they're applying for these various accommodations. So it would be very valuable for owners and residents and associations and board members in other states to be sure that they check with local council to make sure that there are no differences between their state laws and the federal law, and if they are, they need to know what those might be.
So one other thing I want to get out on the table is, and correct me if I'm wrong, but these animals still fall within the same rules and regulations as all the other animals would. As you have to pick up your debris. What if the animals are barking on
That's
that?
a really great question, actually, and I'm glad you brought it up, because if you didn't, I was going to have to do one of those things. Wait 1 second before I conclude. This is important to know. There are two really important things to understand. One is, the general answer is yes, the association is allowed to have and enforce rules relating to service animals and emotional support animals. However, there could be variations. For example, if you have a community that allows maybe only one pet or cats or something of that nature, and you've allowed an accommodation to have other service animal or emotional support animal there, the rules would probably state that pets are not permitted in the pool area. that rule may not apply to your service or emotional support
Oh,
animal.
both of them. Oh.
Exactly. So there's a possibility that the permitted animals under the Fair Housing Act may also be permitted in areas of the common elements or condominium or common areas of an HOA that the other pets would not be permitted to go. And that's going to be, again, highly dependent on the circumstances, especially when it comes to service animals. I mean, it's very obvious that if you have a seeing eye dog, that's going to be permitted everywhere with you. But what's not obvious, I like to talk about the seizure animals. Okay, so if you have a seizure animal, that's not an open and obvious condition. Some people may think it's an emotional support pet when it's really actually not. It's a service animal. And that pet would be permitted in a pool area or in the clubhouse or in the weight room or anywhere else because it needs to be around the owner to detect the potential seizure. So that is going to be a very case-by-case basis to make sure that certain rules, can apply. The same would apply to a rule that requires owners to carry smaller pets through the common elements. That a person with a disability may not have the ability to carry that pet. So everything is going to have to be looked at and tailored to the accommodation that is being given. So that's one thing, but still, rules apply. Not, they can't say anything goes because I have an emotional support pet or a service animal, and we have seen that. And that gets to my second point, especially in those situations where you have an animal that may not be a legitimate emotional support animal. Oftentimes the owners don't really care about the pet rules. They don't often care about other rules either. And so they might let the pet run around unleashed, do whatever it does, do its business, not pick up after it. It barks all hours of the day. It disrupts other neighbors, whatever the case may be. In that instance, it's not just a rule violation in my opinion. I actually think now we're getting back to that whole reasonableness standard that we talked about before. Adam brought it up in the context of whether or not you have to allow the accommodation. Is that particular pet, the squirrel, the potbelly pig, the multiple dogs, are those reasonable accommodations? But once an accommodation is granted, if the conduct of the animal is such that it makes the accommodation unreasonable because it is creating a nuisance in the community, disrupting other residents, maybe it's aggressive. We actually have an issue right now where we have a support pet that is being aggressive, or I should say support animal, that's being aggressive towards others and has even bitten another owner. To me, that now brings us back full circle to whether or not the accommodation is reasonable, and I would argue that it's no longer reasonable. And the owner needs to be notified that that particular animal is no longer a reasonable accommodation because of the conduct of the animal. And while they may still be entitled to an accommodation, that one has to go. And it's not an easy argument to be made, but I do think it's very important for associations to understand that and to use it when necessary, because we can't have owners allowing their pets to do anything they want in the community simply because they believe that it qualifies as an emotional support animal or a service animal.
What about if I have a restaurant in my community? Are they all the same? I mean, can they bring their potbelly pig into the restaurant while they eat?
If it's a restaurant that allows people to come in from off-site, in other words, it's not limited to simply your owners and residents of the community, then it's actually a public accommodation, and it brings us under the Americans with Disabilities Act, and that's even freer. Yes, absolutely, they'd be able to bring it in. It's even less restrictive in that sense. If it's, let's say, a personal club in a very high-end community and only owners and residents are permitted in there, then we get back to the question. It's very similar to the pool area and the other private areas within the community as to whether or not the pets would be allowed in that area. It's going to depend on the nature of the disability and the need for the accommodation.
Well. Do you have anything else you'd like to make sure that we all go away with and scare us a little more? No, not really.
Well, one thing that might scare you a little more, but when we talk about reasonableness and we talk about 4 large dogs in a small condo, probably unreasonable, depends on the circumstances, but probably unreasonable. But one thing to note that we can't get into when we talk about reasonableness, and something we come across a lot is, well, they have an emotional support animal, but it's also a pit bull. We don't want to allow pit bulls. We'll allow emotional support animals, but not pit bulls, not breeds that are deemed to be aggressive. Or, do they really need an 80-pound dog as their animal in a no-pet community? Can't they at least have a 15, 20-pound dog? And the answer to all of the above is no, you can't restrict that at all.
Right.
The breed, the size of the dog, all of that is in play. And all of that, if it's established that they need an emotional support animal, then you have to accept it regardless of breed or weight restrictions or anything else. It's really just that overarching, is it reasonable analysis, but it can't be limited to breed or size of the animal.
So I just have one question before we end. Did the spider make it? Were they allowed to keep the spider? I know you're not allowed to tell us, are you? No. Well, I want to thank you both from the bottom of my heart. Thank you for talking to us. And I
Thank you
hope
so much
you'll
for
come
having
back
us.
and do some more
Absolutely.
podcasts with us.
Certainly.
We've enjoyed it. And we'll put all your information on the website
Great.
so that anybody that needs your services can call you.
Yes, please do.
Thank
Thank
you.
you.
Thank you very much.
This concludes episode 2. We hope you found it helpful and informative. As always, you can join us at camresource.info for more episodes, or go to our YouTube channel, Cam Resource. See you there.
Join us next time for the 2017 Legal Update.